On your first DUI offense, should you speak to the judge to explain your situation? In this video, I'm going to explain why that's a bad idea. This video is part 5 of this important topic, how to get out of a DUI first offense. You should watch parts 1 to 4 where I cover really important information that you should know when you've been charged with your first DUI. I've included links in the description to this video. And you should take our DUI arrest test where you can assess the nature of your arrest to determine if your charges may get withdrawn. I've included a link to the test in the description of this video. In this video, I'm going to cover what you absolutely should not do, and that is speak to the judge to explain your situation. Let me give some context. You've been charged with a DUI for the first time. You're anxious, you're scared about what's happening, and you've not been to court yet. Your first appearance is coming up. And you're telling yourself at your first court appearance, you just want to get in front of the judge to explain yourself. You may not believe you're guilty, or maybe you have some important information that you would like to give and tell to the judge to give context to what happened, or you're just plain sorry and you want the judge to know that. You're sure that the judge will understand and agree with what you have to say, and after listening to you, the judge will either drop your DUI charge or will replace your DUI charge with a lesser charge that is not a criminal charge, such as careless driving. On the face of it, that idea makes sense, but here's the problem. It won't work, and here's why. At the start of your case, the key decision maker is the Crown and not the judge. The Crown is the lawyer that's in charge of prosecuting the case against you. When the Crown gets your case, which happens before your first appearance, the Crown must decide whether they are going to proceed with your DUI charge or not. The Crown makes their decision based on a two-part test. The first test is whether there is a reasonable prospect of a conviction on your DUI charge, given the evidence that the Crown believes it will have. And the second test is, even if there is a reasonable prospect of a conviction, is it in the public interest to proceed with the DUI charge against you? And those tests that the Crown must apply, it's the Crown that does this, not the judge. So explaining your circumstances to the judge at your first court appearance won't work and will not help your case, because it's the Crown that matters at this stage of your case. Message me if you want to have a confidential and free call about your DUI charge. There are no bad questions.